It's share in time, Deputy McGrath.
Yes.
10 minutes each.
Come on, good.
Is that agreed?
Thank you, Cahill. I rise today to speak against the main provisions of this bill, which under the circumstances must be one of the most misleadingly titled bills that has ever come before the House. But before I do, I must express my disgust on hearing Deputy Aidan O'Riordan stand up before this House earlier and lecture the rest of us about betraying the Republic because some of us who hold different conception of what the constitutional protection of the unborn means in practice. Neither the Deputy or his party are in any position to lecture the rest of us about distorting this debate when he himself has been recorded how he felt it necessary to deceive the people on the intentions of this bill so as to gain time for a more liberal regime. And that has been recorded, whether covertly or otherwise. I am on the record as saying this bill is deeply coercive and unworkable. It pays lip service to the concept of protecting women's health and the life of the unborn. And despite all its so-called restrictiveness, it will set a precedent, the consequences of which I do not believe many in this House are really aware. This bill, for the first time, provides legislative protection for the direct intentional killing of the unborn child, where the risk of suicide is deemed to be of sufficient force that it represents a real and substantial risk to the life of the mother. For all practical purposes, this bill, in its current form, is shaped in every conceivable way by the ideological premise which the Labour Party have successfully bullied the Fine Gael Party into accepting. It is not evidence-based. It ignores clinical best practice internationally. It effectively coerces members of the psychiatric profession into a role which they have vocally resisted since the onset of the so-called debate. How any of this helps vulnerable women and their unborn children remains confusing, to say the least. Although the government has claimed all along that there is no option but to legislate, this is widely contested. Legal experts have already pointed out that they know of no other area of law where a threat of suicide is sufficient to make legal what would otherwise be illegal. They further note that the notion that a simple threat of suicide would make right something that would otherwise be wrong is a really dangerous principle. We all must surely accept that. In many ways, we are now actually in a worse situation in terms of clarity because of the inherent contradictions contained within the bill. Instead of leaving this issue in the hands of medical professionals who could have been tasked with drawing up a more robust guidelines, we now have a bill that seeks to reconcile the irreconcilable in terms of fusing Fine Gael and Labour policy on this issue. A process that, as we know, has been riven with protracted political wrangling and exposure of hidden agendas, particularly on the Labour side. Indeed, the whole farce that was the Health Committee hearings on the bill is something that I have been pointing out for some time. Time and again we have seen inconsistent and misleading statements being issued from the chairman of the committee. For example, as I have already pointed out in this House, in his closing statement on the hearings, the chairman of the Oireachtas Joint Committee on Health and Children explicitly stated that the Protection of Life During Pregnancy Bill, as it stood, only provided a framework but not the detail. He stated it was not the final bill, it was not the new law, and it was a preliminary document. The next morning, alas, less than 12 hours later, during an interview on national radio, the said same chairman explicitly stated provisions will be made. The chairman stated explicitly that provisions will be made in the bill for a woman to obtain an abortion on the grounds of a risk of suicide during pregnancy. This is completely conflicting state of affairs and shows the chairman had already decided to ignore the testimony of those psychiatrists and legal experts who have demonstrated such a provision is contrary to the best medical and legal practice. I think that was a grievous insult to the good people who came before us in committee willingly. Such comments confirm to those of us who oppose the main thrust of the bill that this process of so-called investigation had been marked by political expediency from the outset and was never serious in its intention to objectively examine the heads of the bill. As a member of the committee, I sat there and watched in dismay as the shambolic nature of the proceedings continued, week after week, day after day. What we cannot say at the end of those hearings is that there has been a fair and reasonable debate. That is a great shame, not only for those of us who oppose the bill, but also the healthy implementation of truly democratic procedures which are valuable to us all. I want to come now to the main points of this prepared piece of disastrous legislation. Contrary to what the government has been repeatedly insinuated, the Oireachtas is under no constitutional duty to legislate for abortion on the grounds of threatened suicide as per X case. There is no such thing as a constitutional duty to legislate for Supreme Court decision, and it's completely wrong to suggest otherwise. In any event, the X case judgment is not a formally binding precedent, even from the perspective of the courts, never mind the Oireachtas. The controversial aspect of the X case, the permissibility of abortion as a treatment for suicidality, was conceded without argument and therefore does not form part of a binding precedent. A basic principle of Irish law is that all points entirely overlooked or conceded without argument are not part of the precedent of the case. Contrary to what the government has insinuated, the A, B and C judgment by the European Court of Human Rights does not require Ireland to legislate for abortion on the grounds of threatened suicide. Does not. That decision concerned a pregnant cancer patient looking for clarity as to what treatment was lawfully available to her. The rules of the Committee of Ministers require Ireland to adopt measures that are effective for preventing the recurrence of the breach found in the particular case. Applicant C, the only successful applicant, was not suicidal. A suicide-based exemption from the statute law on abortion would not have helped her in any way. The X case had no psychiatric evidence whatsoever, literally none. The Oireachtas is now in possession of psychiatric evidence completely unheard of by the higher courts 21 years ago. Let's not forget that. We're making the case that it's 21 years on and we have done nothing. We have much more evidence now than we had then. The Oireachtas is constitutionally free to take on board that evidence and craft its laws accordingly, it's my belief. The evidence unknown to the High Court and Supreme Court 21 years ago is this. Abortion is not a treatment for suicidal ideation or intent, and that's been accepted by all sides. This fact, widely acknowledged even by pro-choice psychiatrists, is the faulty premise upon which both the X case and the current abortion bill rest. There is simply no psychiatric textbook or peer-reviewed study which purports that abortion is a legitimate treatment for suicidal ideation or intent. The bill does not provide a time limit on the intentional abortion of a child. This is perhaps the single most horrifying aspect of the legislation. It does not provide a time limit on the intentional abortion of a child. Just think of that. Despite the Minister's claims to the contrary, the bill confers no duty on medical professionals to take account of the unborn child's welfare when deciding on an intentional abortion. The bill makes no provision for the care of a child delivered prematurely as a supposed treatment for suicidal intent. No provision whatsoever. The bill provides no legal representative on behalf of the unborn child to advocate that his or her welfare be taken into consideration. Government spokespeople have argued that the legislation will be restrictive. They said that there are two high threshold tests to be satisfied for an abortion to be authorised. A, there must be a real and substantial threat to the life of the woman. B, the risk can only be averted by abortion. It is well established, however, that a person is legally free to withhold consent to any and all medical treatment. If a woman refuses all treatment offered to her, it cannot be long before abortion becomes, almost by default, the only treatment remaining that can save her life. This is the practical reality provided for by a plain reading of this bill. It shows precisely why abortion on mental health grounds is such an elastic legal basis for access to abortion.
2 minutes remaining.
Good. Last but not least, without exception, every jurisdiction that has provided abortion on some kind of mental health grounds has experienced an unintended widening of abortion access, and that's widely acknowledged and known fact. The fact that Ireland's mental health grounds is narrower on its face than other jurisdictions is irrelevant. Totally irrelevant. The fact that Ireland's mental health grounds, that we're told, is narrower on its face than other jurisdictions is irrelevant. No matter how narrow or wide the original mental health grounds for abortion have been, every jurisdiction has experienced an unintended widening of those grounds in practice. And we need to look over our seas at the British Isles to see what happened and see the said gentleman minister that brought it in and what he feels now. Without exception, every jurisdiction providing for abortion on mental health grounds has attempted to enshrine safeguards into its laws. But alas, without exception, these safeguards look safer on the page of statute book than they do in a real-life clinic. And I have to say in conclusion, Cathaoirleach, I really am aghast at the speed and the bully-by tactics used in this bill. And the Taoiseach promised us much time. I could get 10 minutes, was all I could get to speak on this bill. Such a fundamental life-changing, and especially killing of the unborn. And we get 10 minutes to discuss it. I got 5 minutes last week on the reform. I'm part of the technical group and I'm not complaining of that amount of time. That's all the time we could get for this life-changing bill. And the same with his banishing the Senate. I think it's an insult to democracy. It's an insult to the electorate that put me and all of us in here, that we get 10 minutes for this. And as for the charade of the hearings and the whole setting up of the committee was a charade that will be unmasked in the fullness of time. And people aren't being fooled. And people aren't fools. They see what's going on. And it's the tail wagging the dog, the Labour Party, where they've got little else, nothing else out of this government for their supporters or for the public. I think this is manna from heaven that this will be. And when they had to be found out by tape, covertly, it's a sad situation to say that this was only first step on the Liberal regime. So I think it's an insult to the public, and it's an abhorrence what's been passed to this House.